Hello and welcome to this talk on bringing a claim for judicial review. My name's Declan O'Dempsey, I'm a barrister at Cloisters Chambers, and in this talk I'm going to be talking about bundles and documents in the administrative court. You have to file the bundle of documents at the same time as the skeleton argument in the case of a substantive hearing. That's as a result of the Civil Procedure Rules, Part 54A, and the practice direction at 16. Now this means that you must file the bundle of documents if there are no other directions applicable, not less than 21 days before the date of the hearing of the claim. That's the rule if no other directions apply. However, normally other directions are given. I'll be talking about that later on, and this results in a requirement to file or lodge the bundle for a substantive hearing 1 month before the substantive hearing, so at least a month, that's 4 weeks before the substantive hearing. Now, you may feel the urge not to put everything relevant into the bundle. If you're feeling sneaky, don't. The Administrative Court Guide by the Administrative Court on how to bring one of these judicial review claims says that the bundle of documents should contain all the relevant documents, including any documents required to be included by the defendant or any other party who's going to make representations at the hearing. So if you've got the urge to use this as a tactical moment, don't, because it'll just lead to trouble later on. The court expects to have a joint bundle of documents for the hearing. Now this includes all the documents to which any party that's going to be present at the hearing, to which they'll refer. The court doesn't expect to have documents handed up to it during the course of the hearing, save in exceptional circumstances. And whether it'll allow documents to come in will always be subject to its permission to adduce or bring in documents or evidence in this way, simply by handing them up, in other words. So you can see the disadvantage of trying to be sneaky and keeping documents which the other side want in the bundle out of the bundle. For a start, they won't let you do that, and if necessary they'll make applications to the court to ensure that documents go in the bundle. But also it simply means that parties end up handing up documents. If you've kept the document out of the bundle, then that will look bad on you. Likewise, if you've kept a document out of the bundle yourself and want to put it in at the hearing, this will be dangerous. You may not be able to rely on it. You may not be able to put it in evidence, and that may damage your case. So avoid the urge to try and use the compilation of the bundle as a moment to gain a tactical advantage. That was the rule about substantive hearings and when you need to put the bundle into the court. But in other types of hearings, interim hearings, first of all, if there are directions relating to hearing, obviously comply with them. But if there are no directions about the production of bundles, for example, if there's an urgent application that's been made by a party, you should still try to make sure that all relevant documents are before the court. Any bundle of documents which are to be put before the court needs to be served on the court and on the other party or parties in good time before the hearing. Now, good time in this context means at least 3 clear days before most ordinary hearings. If the matter's urgent, the bundle should be served on the court and the other parties no later than 1 p.m. on the day before the hearing. In an earlier talk, I dealt with what's meant by an urgent hearing. Do look at that talk if you think you might have an urgent hearing, and if you do have that type of hearing, then there are still rules relating to the production of the bundle, and the bundle, as it says, needs to be served on the court and other parties no later than 1 p.m. on the day before the hearing. The court guidance talks about the format of the bundle. essentially any collection of documents that is going to go before the court is a bundle. However, bundles should ideally be put in files, and the files need to be sufficiently large to accommodate the documents contained in them. In other words, don't overfill the file, and there are several practical reasons for that. Lever arch files are constructed in such a way that if they have too much paper in them, that tends to distort the metal rods which keep the papers together. And that means when the judge tries to turn a page, the metal rods are not meeting up with the metal arch, and that means that there is a ripping of the page as it turns, or it just proves to be impossible to turn the pages in order to get to a particular page without opening the file and scattering the contents of the file over the desk. Now you can imagine if you're a judge trying to deal with a case quickly and fairly and concentrating on the relevant matter, this sort of thing will be very irritating indeed. However, it happens in many cases. It's a false economy to think that you'll just use one bundle when in fact you need more than one bundle. So do try to think practically about the way in which the bundles you're putting in are going to be used. And if you've got difficulty in turning the pages without distorting your lever arch file, then it's very sensible to split that bundle into more than one lever arch file. If you do that, you'll need to indicate which pages are in which bundle, and you should do that on the spine of the bundle. The Administrative Court Guide says that the pages should be numbered sequentially, and it says that the bundles should be indexed. Now this means you add a few pages at the front which provide an index to the bundle, and that means you need to construct a table which has the description of the document, not a lengthy description, but just what it is. It might be letter from the local council to yourself, dated whatever the date is, and then you give the page in a separate column in this table. So column 1 will be the description of the document, column 2 will be the page at which that document starts, and followed by a dash, and then the number of the page on which that document finishes. Now it's very important that the bundle should be numbered sequentially, and what that means is that you don't restart the numbering once you've started the numbering within the bundle. So what you do is have, let's say, page 1 to 500. What you don't do is to have page 1 to 30 and then a tab, followed by page 1 to 30 and then another tab, followed by page 1 to 5 and another tab, and so forth. The problem is obvious. Either the judge has to be able to find all the tabs first and then the page number, or the judge will simply feel that the bundle is not numbered properly, and that will again irritate the judge, and you want to avoid that. So number the pages from 1 to n, and then in the index any individual page number in the index will pick out an individual page in a document in the bundle. So number the pages sequentially and index the bundle. The bundle spines should be clearly marked with the reference number of the case and the name of the parties. The reason for this is that the judge may be looking at the documents in his or her chambers and may have many cases to look at the same time. It's very important that the judge should be able to locate your case quickly and easily. And the best way of doing that is to put the number on the spine, so that if the bundles are put on a shelf, then your case can be found very quickly, and again, it doesn't waste the judge's time. The Administrative Court Guide says more about the formatting. Photocopying should be on two-sided format, so you don't have one side of the page blank all the time. You photocopy on both sides of the page. And the photocopying should be in portrait format and not landscape. The reason for that is you don't want the judge having to turn the bundle in the middle of the case in order to be able to read a document, if you can possibly avoid it. The reason for that is not that the judges are being precious, but the judge's desk, when they're hearing your case, may be full of papers, and it can be very disruptive indeed to have to turn a large bundle around mid-case. It can result in things being knocked over, and therefore it's worth trying to avoid that. A very important point to bear in mind is that photocopies need to be legible. Now, that doesn't mean that somebody who is intimately familiar with the case and knows what the original document looks like is able to read the document, even though to everybody else it looks like a picture of greyness or worse. What it means is that somebody looking at that document who isn't familiar with the case, i.e. the judge, can easily read what is on it. Now, if you cannot do that, then what you may need to do is to provide a transcript on a following page of the document which would otherwise be difficult to read. But ideally, what you should do is to make sure that your photocopies are legible, and that may mean that you need to play around with the greyness setting on the photocopier that you're photocopying on. Next, documents should be presented in a chronological order. Again, that means in a timeline order, and the reason for that, again, is to show to the judge how the case unfolds in terms of the documents. Earlier documents come earlier in the bundle. If the amount of documentation is extensive, and the court guide talks about a bundle of more than 500 pages, then you should try to agree with the other parties a core bundle of key documents. So that's a very slim bundle of the absolutely essential documents in the bundle. Now, in those cases, the parties should think about, and they should think about this together, they should think about including only the important and relevant parts of any long document in the court bundle, as opposed to copying the whole of that document. Now, you need to talk to the other side about this, because there may well be long policy documents in your case which belong to the local authority or to the government department. And in fact, you don't need the whole of that. You just need 1 page or 2 pages. And it may be that the defendant will need other pages from it as well. But it's important that you should talk to the public authority and their lawyers to make sure that only the relevant parts of a document are included. And that means you need to tell the other side what you say are the relevant parts of the document. There shouldn't be any problem about doing this, because of course in your claim and your skeleton argument you will be isolating the relevant parts of any documents, and therefore you ought to be able to say to the other side, without damaging your case because they already know about it, what the relevant parts of your documents are. And similarly, they ought to be prepared to do the same for you. If you fail to observe those rules about bundles, then the judge may refuse to read the bundle. You may get a judge directing that a revised bundle is submitted. in order that the revised bundle should comply. And if that happens, the judge may disallow the costs of preparing the bundle or may make an adverse costs order against the defaulting party. I want to say a few words about the timing of the lodging of trial bundles. Normally directions are given for substantive hearings, but trial bundles need to be lodged in good time before any hearing, and this means that the trial bundle must be lodged on or before the date set out by the court in any directions. The direction that's normally given, or normally ordered by the court in relation to a substantive hearing, is that the trial bundle must be filed and served not less than 4 weeks before the date of the hearing. If there are no directions, then in relation to substantive hearings, the trial bundles must be lodged when the claimant's due to lodge skeleton arguments, so that's 21 days before the substantive hearing. And in relation to all other hearings, or where there are no specific directions in place, any documents must be filed at the court as soon as possible and in good time before the hearing. What happens if you're late filing the bundle? If it's unavoidable that your bundle is going to be submitted late, then when you submit it, you should clearly state the date of the hearing on the bundle. The bundle should be accompanied by a letter to the Administrative Court Office explaining in full the reasons for the late submission. The guide says you must set out the reasons for the late submission. If you don't make it clear that the bundles relate to a hearing which is imminent, this may result in the bundles not being put before the judge at all in advance of the hearing. So it's very important that if you are late, you write to the court and make sure that it knows that the bundle you're sending in relates to a hearing that is coming up very soon. If you are in default of the requirements, and if your trial bundle or your bundle of documents for the hearing doesn't comply, or if you serve it late, then the court may refuse to allow you to rely on the bundle, or it may make an adverse costs order against you. You will need to seek relief from sanctions under the Civil Procedure Rules, and you'll need to have a look at Civil Procedure Rule 3.9 and the earlier talk in which I deal with relief from sanctions.